Thank you guys. Done?
Good evening, everybody. Welcome to Judicata, the NLIU Law Podcast. Today, we have a very special guest with us. We have with us here Mr. Varun K. Chopra. He's the managing partner at VKC Law Offices, New Delhi. He's also an advocate with over 20 years of experience in commercial and taxation laws. We are very proud to call Mr. Chopra an alumnus of NLIU Bhopal. He started his career with Khaitan Co, where he worked on complex commercial and corporate litigation issues. He's also worked closely with eminent senior advocates and the Attorney General for India. His career has spanned across different legal fields, and the VKC law offices endorse the diversity that he brings up. Today, he has been recognized as one of India's top 40 under 40 legal professionals. He's also one of the only advocates to have ever represented a presidential candidate. He has been appointed as a mediator by the Supreme Court, and he also works as an arbitrator under the Delhi High Court and the DIAC. He brings in the depth and perspective to today's podcast, and we're very happy to have him here. It's a privilege to be talking to you, sir.
Thank you, Judicata, for having me on your show. It's a privilege to be part of my being an alumnus of NLIU. It's a privilege to be on a podcast by NLIU. It's an honor.
So to begin with, how does coming back to your alma mater feel?
See, like we always say, you leave the alma mater never leaves you. So you're bound to come back. You're bound to be back to your roots. You're bound to give to your college, and it's amazing. It's nostalgia.
So from graduating from NLIU Bhopal to having 200 reported Supreme Court judgments, if I may ask, what is that one case or any mentor who shaped this diverse journey of yours?
See, mentors are many, but for a lawyer, you have to mentor yourself with discipline and to read every day and to analyze the law individually. That's how you mentor yourself. There are mentors, of course, there are several seniors whom I work with. But then I realized one thing, but you have to mentor yourself. That is the most important thing as a lawyer. And lawyers' profession is very diversified, and you meet so many people. It is so diversified that you don't know what you're doing tomorrow, you don't know what you're doing day after, or you don't know what you're doing today. So you have to be there and do the things rightly and in a manner where you know the law is right and you are serving your client in the best manner.
So you have worked with multiple big corporations. You started your career with Khaitan Co. And for any young advocate, it is a huge opportunity to have. And after working in all these diverse fields, at what point did you decide to step up on your own, to start your own brand? And how did you get that confidence? How was that transition like?
See, I'll speak for myself. When I joined Khaitan, joined Khaitan in 2007. And then I left in 2011. And at that point of time, I was a young fellow. Leaving in 2011, I also had an opportunity to join another eminent law firm, which is equivalent to Khaitan, based in Bombay. But I did not join that. Why did I? Why? That's the question even I ask myself today. Why? But then that why's answer, I can give it today. That's why I'm on your podcast in Judicata. It is the name a lawyer wants to make himself. It is the name. When you're working with Khaitan, you're making the brand of Khaitan big. As a lawyer, I wanted to have my own individual identity. I wanted to be known as Varun K. Chopra as a lawyer. That is the reason I went to sea. And you're swimming. And I'll tell you one thing, when you get into the litigation field as a first generation lawyer, it is survival for the fittest. You have to work hard. You have to work very, very hard. In fact, I started with 4 files. My office was my car. When I started, I used to have my meetings at India Gate on the phone. Now, with God's grace, I have more than 6,000 files. So that is the spirit which drives you, that you have to achieve something, you have to have a name in life.
That is extremely inspiring, sir.
Thank you.
And even today, we have a lot of first-generation lawyers in our college. And hearing from you how you started in your car, it's an extremely inspiring experience.
And that car was also not mine, in fact. It was borrowed from my father. So I still remember that. And amazing experiences.
So from starting there to finally being the sole representative of Srimati Meera Kumar and Shri Gopal Krishna. This litigation experience is far more distinct and it is far different from your usual practice area or the usual practice area that your firm endorses: commercial practice, corporate laws, competition laws. So, how did that transition feel like for you, and how did that come along the way?
I would just say it's God's blessing that I got that opportunity to represent the presidential and the vice presidential candidates at that point in time. But apart from corporate commercial, my forte is also election laws. I worked a lot in election laws and represented several political parties and several political candidates across the country in election laws. So this was something which I'm very passionate about. Probably God gave me that opportunity to represent them, and it was a mind-boggling experience. Never felt like that. You have all the most powerful people around you, and then you're representing the person who might or may not be the president of this country, which is quite an experience, I must say, and learned a lot. I learned a lot, and presidential elections are very different from vice presidential election. Okay, so one has to know how you need to contact the leaders, and it was a coalition election where they were where they had the candidate as Meera Kumarji. So at that point of time, there was a lot of political coalitions happening, and to manage that and be a part of that, that makes you learn a lot in life. So it was a great experience. I must say.
Indeed, sir, because the specific case that we're talking about, that might not have just been legal. It was an amalgamation of politics, law.
Absolutely right. It was amalgamation of everything. It was amalgamation of everything that you were going to represent the leader of the defense in the country. Just imagine that.
How did that engagement with politics shape your perspective as a lawyer after that case?
It gives you a perspective to understand where you stand. It gives you a perspective of where you stand, and it also makes you realize that if you have an aspiration to grow in life, you should learn. I always say one thing, you see, our friends or anyone's success should not be your jealousy. It should be a path of inspiration, actually. Someone's success should always be a path of your inspiration in order to grow in life. Never take it as jealousy or in any matter, thinking that why does he have it, why don't I have it? You're just wasting your energy. Rather than be inspired by it, go for it. That's what I mean.
That is amazing, sir. And maybe it is this go for it attitude of yours that has come as such a diverse brand that you've built.
See, go for it only comes when you have the fire in your belly. If you don't have that, you never go for it. So always have that fire in your belly to do it. To do it, to achieve something, to have a name. I come back to my alma mater. I was a very naughty boy in my college days. Of course, I was. But when I come back today, my teachers are proud of me. I believe so. But I think that's the reason I'm with Judicata today. So I believe I made myself proud. I made my teachers proud. Be naughty, but go for it.
Indeed, sir. We're proud to have you as an alumnus of our college. Sir, you have maintained a very balanced approach, and your career is very balanced and unconventional with regard to the different law fields that you've explored over time from the beginning of your career. So, moving on from Khaitan, starting your own practice, and then coming to arbitration. Arbitration has been a big part of your career.
Correct.
So, for us as law students, when we see it arbitration as a really enticing field, what is that one mistake that you see young lawyers making while stepping into the arbitration field that they later regret?
Every lawyer actually feels like that. They think that arbitration is the first step for litigation. In fact, they believe that because once you have an arbitration, of course, there'll be section 34. They'll go to the court, there'll be an appeal, etc., etc. Don't think like that. Arbitration is a concept of conciliation between the first aspect of arbitration is in the Arbitration Conciliation Act also first is conciliation. When you go into arbitration, your concept should be that is there any opportunity between the parties that I can conciliate? Can the parties come together and amicably settle the matter? That should be the view of a lawyer. Rather than entangling the entire litigation and making a big litigation out of it. Of course, it will serve you commercially, but then eventually it will not serve you. That's what I believe. And that's the little mistake which young lawyers intend to do, I believe, that they think that arbitration is the first step for our litigation. No, it is not. Arbitration should be the last step. Close it on that.
If I may ask, how is arbitration intellectually different from traditional legal practice?
Arbitration is intellectually different because the approach is different. The approach in arbitration is completely different. Approach in arbitration is where parties have a dispute. There's an arbitrator. He is not only an arbitrator, he also sits there as a person who can conciliate or probably amicably settle the issue. So in arbitration, when you approach a matter, of course, there could be dispute, there could be evidence, etc., which happen in arbitration. But what do? You handle it in a manner to see any loopholes in the matter that can we settle it. That should be the approach. Not that, oh, there's a loophole, let's cover it and we'll take it out in appeal. Don't do that. The concept of arbitration goes away.
So, when talking about arbitration as a concept, many clients would come to you, many clients would choose arbitration thinking of it to be faster, clearer, much better. Now, we do realize that arbitration does deliver on that promise, but which are those silent aspects where it quietly fails to deliver on that promise in current times?
See, like you said, yes, it's a faster process. It is a faster process, and I would suggest all corporates would they, of course, opt for arbitration initially. But nowadays, what is happening is with so much of burden of arbitration, the arbitrators are also fatigued. They're not able to take it forward. They're not able to complete their assignments in time. So it lingers on. It goes on. Parties agree, yes, you can extend the time. There's no problem in it. You can definitely extend the time.
Indeed, and arbitration, especially Indian arbitration, has come a long way. And in current times, we see institutional supports like from institutions like DIAC. So where do you think is the balance, like especially in Indian arbitration, where can we strike the balance between ad hoc and institutional arbitrations?
See, I would always recommend institutional arbitrations. Why? Because they're systematic, they're procedural, and it is confined to timelines. It is confined to a fee schedule. It is confined to the procedure which has to be maintained. So what happens in that is that the procedure follows, the timeline is maintained, and you close the arbitration as fast as possible because that's what the clients are coming for. The clients are coming for a quick remedy or a faster remedy rather than going and litigating in court. So that's the reason institutional arbitrations, I would always push for institutional arbitration. In fact, I'm doing several arbitrations with TIAC, several of them. So I understand how they work. It's institutionalized. The procedure is smooth. And clients actually go for it. They say there is an institution who will do it.
That's amazing. But when we talk about institutional arbitration, of course, it is a much cleaner approach. It is more organized.
Right.
But if we talk about future and with how growing demand arbitration has in India, is there any looming scare that arbitration or institutional arbitration might also face the same fate that litigation faced with overburdening judgments, overburdening courts, and delayed procedures?
Very, very good question that you asked. It is bound to happen. India is a very developing country. By 2030, we're going to be one of the largest economies in the world. Correct? So it's bound to happen. So that is the reason there is a concept which is being promoted by the entire judiciary these days is mediation. So that could be actually the first step which may curtail the number of arbitrations which may happen. If you go into mediation, and of course, well, people may say that once there is a settlement in mediation, it is not a decree, but the Mediation Act today says, yes, it will be a decree. It will be counted as a decree. Of course, the sections are yet to be notified, but we are looking forward to it. If that Mediation Act kicks in of 2023 and the sections are notified, in my opinion, of course, arbitrations are going to increase, the disputes are going to increase, India is going to develop, but with that Mediation Act coming in, it will be able to balance.
Mediation is a mandate in commercial proceedings.
Yes, definitely.
So it is definitely going to help with arbitration cases.
200%. 200%. In fact, I often opine my clients that there should be a mediation clause and then an arbitration clause in the agreements. The first step should be mediation, then you go into arbitration. rather than directly going to arbitration.
Yes, indeed. But what is that one looming scare that the clients face, and why do the clients not choose to like stick to mediation and then proceed to
Because
arbitration?
earlier, what mediation, the clients always thought that the mediation is merely talks between the clients and it's not going to have any concrete way forward. But now the situation is going to change. That's what I'm saying. The Mediation Act comes in, the situation will change, definitely change. And clients will definitely go into mediation, and mediation is something not new. Mediation has been in CPC in Section 89 for years, for decades. People, the first concept of CPC is also to mediate. And that once that mediation comes in and they have a supporting act and a legislation, of course clients will approach. Of course clients will go for it. Why not?
That was amazing, sir. And maybe mediation will help out.
I hope so. I'm a mediator by the Supreme Court. So I've done a lot of mediations. I know how it helps. It does help.
How does being a mediator differ from your experience as being an arbitrator? What different aspects do you focus on?
See, arbitrator, you have to settle a dispute. As a mediator, you have to come to a settlement. That's the difference. Arbitrator, you have to settle a dispute. And as a mediator, you have to settle. There's a big, not a very big difference. Of course, there's a dispute there also, but the vision there is to settle. Vision here is to give a verdict as an arbitrator of the dispute or the list which is before you.
The future does look really promising.
I hope so. I hope so. I hope so. I hope so. It's commercially very good for the lawyers also.
So now that we are done, now that we have talked about arbitration's future, let's move on to a different wing of your career. You are also an avid environmentalist.
Yes, which I really love. Environment is something we Delhiites love. And we cherish environment because, we come from a gas chamber in Delhi. So anywhere where there's good environment, good air, we love it.
So for listeners who may not have followed the Aravalli Hills judgment that well,
Crucial.
it is definitely very crucial. How do you think that judgment shaped India's perspective towards environmental law?
See, if you know the background of Aravalli is the oldest fold mountains in India. And Aravalli, because of Aravallis, Delhi is not a desert. Right? They stop the desert from reaching to Delhi. They are the barriers. And the old definition, if I look at it, the previous judgment, which has now been put in abeyance, and the report of the committee has been put in abeyance by Justice Suryakant, the current Chief Justice of India. So if you look at that definition, it was draconian. It would have taken the Aravallis out of the landscape completely. It said that any hill which is under 100 meters is not Aravalli. How can that be? It's impossible. Nothing would be Aravalli then. And it would have made illegal mining rampant in that area. But I did that Aravalli matter, and it was a great learning. And in fact, I must compliment the Chief Justice of India who took so much cognizance of this matter because it was going haywire. There were several societies, those who were against it. There was a lot of hue and cry in society. That is the reason the Supreme Court of India took so much cognizance of, which one should compliment. And they passed a brilliant order by having a high power committee, etc., of experts, which is great.
Indeed, sir, it is absolutely great. But when we look at the population of India and how India as a developing country always has urban expansion facing and hindering environmental protection, environmental regulations. So working in environmental laws, do you think more regulations is any way going to help the case?
There are regulations already. You bring in more regulations, you're going to complicate it more and give more loopholes to the people, those who want to urbanize it as a weapon. There are regulations. There are several regulations in this country and legislations which support the environment. But if you give a handhold and bring in some new legislation, the builders and the building companies, they're going to come in and they're going to challenge that law. Again, it will be stalled. So legislation is not required. Implementation of that legislation is required. That is crucial. How you implement it, that is crucial. Implementation can't be where you say Aravalli Hills, less than 100 meters is not Aravalli Hills. That is not implementation. That is the reason there is a continuing mandamus of Team Godawaran in the Supreme Court. It is going on. Why? To protect the environment. All small issues of environment are taken up by the Supreme Court in Team Godawaran.
And we're seeing the courts' encouragement towards environmental
Yes, they are very active. Very active.
Indeed, the courts have become extremely active right now.
Absolutely.
But now that we look at the future, what roles can courts play? Can they, or the expert committees, what essential roles can courts play?
Court has recently played a role on 29th of December 2025 by taking us to court, sumo to cognizance over Aravalli. That's the role the courts are playing to protect the environment.
Can courts also help public understanding and public awareness about environmental issues?
For that, public has to understand first. Courts can, of course, lay down the law. But now, if the people and the society is not able to adapt those laws, what can the court do? Can the court go to every person and say, no, this is the law, you have to implement it? Can the court go and say, no, you should be fined or you will be imprisoned because you're not following the law? Of course, that's law. But then how many people, this civic sense which people have to go into and respect the environment, that is not happening. That is not happening because the desire and the greed is growing multifold. There's too much of desire, too much of greed which people have these days, which is growing multifold. Which, if that goes, will not help the environment.
But when we see the younger generation stepping in, we as a generation, we are much more environmentally aware. And the new lawyers that are coming in this field, as law students, we take interest in environmental laws. So when you see that young lawyers are considering this as an enticing field, do you, as an experienced advocate, do you suggest something to these young lawyers who wish to pursue environmental laws?
Best of luck. That's what I will say. Because it's a very daunting field. It's a big task. A lot of lawyers, young lawyers, those who want to get into environmental laws, they should pursue it. And the best way to is that once they're pursuing it, the only advice I'll give them is first respect the environment and then only then pursue it. Don't be hypocritical of yourself. It will not help. So if you love the environment, only then pursue it. Because that'll create a passion in your mind to be an environmental lawyer.
You must have worked with a lot of young such lawyers, environmental lawyers, or people who are intrigued by environmental laws.
I have. So, but I'll tell you one thing. Passion is not everything. And I always say one thing, law is logic. Every logic is not law. Always remember that. So you have to think in that focus. Whether it is the law or it is my logic or it's my passion driving me. No, you should not do this to the environment. That's not going to help. You need to read the laws. You should be within that laws to bring your passion out. Can't be beyond that.
Any specific warnings or any specific suggestion you would give to a young lawyer who wishes to join your team as an environmental lawyer?
Don't use paper. Go to e-filing. That's my suggestion. That's the first step you can do as a lawyer. And me as a lawyer, I don't use paper at all. My entire office is e-filing. And on Liquid, and I use my softwares.
That is very noble, sir.
That's the first step as a lawyer you can do. Do that. Let's see if you can do that. If you're able to do that, then it's a different thing.
So, apart from environmental law, just for young lawyers who wish to come join your team or wish to follow you as a leader, as a mentor, any advice that you would want to give to them?
I'm not a leader. I could be a mentor. So the only advice I'll give as young lawyers, those who want to join litigation, is this. Litigation is a passion. And law is your mistress. Believe that in life. If you want to love law, love it. And have that feel in yourself that you want to do it. You want to do it. You want to bring out a new law. You should have that passion. That if I argue this point, will there be a new law settled? Will there be a reported judgment? That's the passion a young lawyer should have. That he can come back home and tell his parents, see, I have a judgment under 141. It's in my name. I've got the law settled in the country. And that law follows. Be that passionate. And if any young lawyers can do that, it's amazing. It's amazing. You are driven to a different level in life. You are driven to a different level. See, I would also suggest young lawyers to see archives of Mr. Farid Nariman. A beautiful archives. These young lawyers should listen to it. As a young lawyer, it's not that every day it will rain, every day you will have work. When you don't have it's not that you should not go to the court. You should go to the court, but not to sit in the cafeteria and have mumpali and chai there. No, don't do that. Go to the courtroom, sit down and watch the court. Observe the court, what is happening in the court. You learn. You learn the body language of the judge. You see how he's bending, what kind of cases. You learn those things. So as a young lawyer, you have so much of time. Man, that's the time you utilize it. Go to the court, sit down in the court, observe the court. It's beautiful. I personally speaking, I don't know anything except law. I cannot do anything except law. I thought to myself sometimes, should I become an entrepreneur? Can I do some business? So my mother and my wife tells me you can't do anything except law. Now my daughter also tells me you can't do anything except law. So I feel nice because I'm passionate about it. See, merely winning a case, coming out of the courtroom, you win a case, you don't win a case, your client wins the case. You just done your duty in the court. And like you always, all of us know, we are the officers of the court. That's the first principle, right? You fight with a lawyer in the court, you have your competent friend who's on the other side, you fight. You go loggerheads with each other. But what do? When you come outside, you have a cup of coffee. Why? It's not me fighting, it's my client fighting with your client. And lawyers never lose. It's the client lose of it. Always remember that. You do your duty. Do your duty as a lawyer. But do it passionately, that's it. Nothing else.
And institutes these days do work to enrich and shine this attitude in their students. That courtroom, like what happens inside a courtroom, let it stay inside a courtroom.
Of course.
Do not let it.
Obviously. Whatever happens in the courtroom between the clients. We are a big fraternity. If we don't support each other, then where will we go?
But when we as new lawyers or as fresh graduates, when we step into the court, we come in with that passion, we take things personally.
You shouldn't. Don't come in the court to take revenge from your friend that I am making lose in a case. That's not what lawyers do in life. Never come like that, you'll never win a case. You know why? Because your mind will be set to make him lose. Your mind will not be set to understand the law and to do the law and to approach the court in a bona fide manner and to be an officer of the court and make your submissions. Your mind will be only there. I have to make him lose. He's my friend. If I win, I'll take. No. Come to the court. Goodbye.
Apart from the ethical part of it, is there anything more or anything crucial that young lawyers tend to underestimate early on in their career?
It's actually very subjective. It depends from person to person. What they underestimate. Young lawyers feel they know everything. Laws to vast, laws to banana, they don't know anything. I still today, almost 2 decades of practice, I still tell myself I don't know law. A lawyer is the first student of law. To learn law, you can't keep a mindset in your mind, I know everything. If you have that mindset, you don't know anything. And youngsters should not keep.
So right now, we graduate, we would have an array of options in front of us, different fields, different options, different fields of law particularly. What specific regulatory litigation or what specific area of law do you think is going to bloom in the next decade?
Bloom in the next decade, arbitration. Mediation and arbitration. In fact, mediation. Mediation is going to, in my opinion, going to be big.
And do you think mediation would be covering a lot of other fields as well?
Mediation is going to reduce litigation. It will. Time will tell. It will. Why is the Supreme Court pushing mediation, MCPC? They're pushing everybody to do mediation. Train mediators. It will reduce litigation without. And mediation is going to build.
So now that we have boiled down your journey across various fields, anything that you would want to say to the students, want to convey to the students, one thing that you've learned across all the fields that you explored?
There's 2 words. Law is intellectual sarcasm. Live up to it and do it. And be a witty lawyer, but not be a shrewd lawyer.
So finally, we currently have the moot court competition going on in NLIU in collaboration with VKC. So, you see moods happening all around. We see a development in moot courts.
That.
What do you think is the future of moot courts? So, how do moot courts help young lawyers?
So see, moot court is just a practice. It's a practice for young lawyers. They compete, they know, and they get to know what is their ifs and cons and what is their abilities and inabilities, and they grow from there. So of course, moot courts will grow. Moot courts will grow. Why not? Why not? They will grow.
Lastly, any message for the participants of the VKCU book camp?
Best of luck. Best of luck. It's merely a competition, but this competition will actually teach you what kind of a lawyer you're becoming. That's about it. Nobody wins or loses. It will teach you what kind of a lawyer you're going to be. That could be a message to all the participants, and best of luck to you.
Thank you so much, sir.
It's a pleasure. It's a pleasure. It's an honor for me to be part of Judicata, part of my alumni NLIU. It's an honor and a privilege. And I must compliment the young team who has organized this in a very immaculate manner. Of course, under the guidance of my teacher and their teacher, Rakama. I must compliment her, and she's always been very kind. I must compliment her. She's always been a guiding beacon for all of us, and she'll always be there. I must compliment her. Thank you, ma'am, so much. And thank you to Judicata for having me.
Thank you, sir.